Good evening, everybody. Good evening. Happy first Thursday of the month, September 1st, 2022. It's a pleasure to be with you today. My name is Carmella George. I am a VA Accredited Claims Agent. I come on monthly to attend from veterans and folks around the country, around the world, really claims. I said I was an agent. What that means is that I'm accredited by the VA to prepare, present, and prosecute claims individually. I am a professional claims advocate. I do that on a daily basis. I represent thousands of veterans, and I absolutely love it. It's the pleasure and the joy of my life. It's a high honor for my clients to choose me to represent them. And what it also means is that I gain a lot of insights from doing this work in mass with a lot of people. I'm on dealing with the VA on dealing with the VA on ways to do things the best way to be most effective, and things of that nature. So that is what I come to share with you tonight. And I will be taking questions live. You leave your questions in the comments that you may have, and I will answer them. I'm not on a couple places I usually am on, just using some new software here, so y'all give me. If you're looking for me in a couple different places, YouTube is mainly where you want to be and mainly where you want to find me from now on. I'm going to slowly start moving from Facebook to YouTube mainly. So, yes, so sign up, watch, like, follow, subscribe on YouTube. Love to have you join me on the journey of just trying to help everybody win their claim, the valid claims. Let's not say any further. We'll hop right into it. Let me see what kind of questions we have. Where are you from tonight? Where are y'all? Locations. Let's see. Let me see some locations, y'all. Fayetteville, North Carolina, Ohio. Let's see. The Great there. West Virginia is in the building. I've been there a while. Spring, Maryland. There's just office. North Carolina. Alaska. Wow, Alaska. Mississippi is in the building. Texas all the way on YouTube tonight. Lots of you joining on YouTube tonight. Thank you for joining me. Boulder City, Nevada. I feel like I'll be in Nevada soon. I don't know what for, but I feel I'll be there soon. Oxnard, California. Never heard of that. Here we go. Hometown fellow right here. Jacksonville, North Carolina. Thank you for joining us, Alan. Thank you for joining us all the way from LinkedIn. I'm new to LinkedIn tonight. Those are joining to LinkedIn just opened to stream to LinkedIn, so I'm streaming to LinkedIn tonight. And you that are joining from there, welcome to the party. We've been doing this. This show makes 2 years that I've been doing this every month. Veterans at no cost, just questions I can take in about an hour. That's what I hear is September 2019 when I first picked up my cell phone, hopped in the Facebook group, and decided that I was just going to type it all out. That was really my motivation, is it just not to have to type it out. It was easier just to say it. And great. So I'm happy to be here. Let's hop into some questions, guys. Thank you for joining Jacksonville. Okay. Let me go back to the top here. Here we go. Hi. Does the VA automatically add SMC when you are rated 100% in one condition and 60 on other conditions, or do you file for it? Okay, so the answer here is probably not as simple as you would like. Yes, the answer is they should automatically process the debt, all these that arise in a claim. And if you had 100% rating and another 60% rating, then yes, they should automatically add that, I believe it's SMCS or housebound, to your award. And in most cases, they do it, but there are some that they don't. And so you have to pay special attention to your award, special attention to the rating code sheet, and just make sure that that actually happened. If it did not happen in your case, be sure to do that SMC, that extra compensation. And just want to have somebody, generally, this opens up the door to this segment. It generally get any award letter, anytime you have won a case or gained a higher percentage, or even the same percentage, just new or an arrow of documentation that's attached to it, letter by letter, character by character, period to period, sentence to sentence, paragraph, everything in it is correct. Make sure you haven't been shorted anything. Make sure your back pay calculation makes sense. The exact calculation in your head with the online calculators. Make sure that it's in a roundabout type of land that it's supposed to be in, or type of number of cases lately where the back pay just hasn't made sense to the back date, the effective date of the award. And I'm fighting for the veteran to get the correct amount of back pay. It's hard for the VA to realize sometimes that their technology, the calculators and the spreadsheets they use to calculate things might calculate them right. Sometimes there are errors, and they need to go in and do things manually, but they haven't been taught to do things manually. And it is a struggle to get them to do an audit, a financial audit of your account. That's what should be requested if you feel like your back pay calculation is not correct. Sometimes it's a struggle to get them to do that correctly. It does not rely on the spreadsheet that they have to calculate a retroactive award. But if you know beyond a shadow of a doubt that the calculation is for it, if you have to ask for a hearing, if you have to make all the noise you have to make, squeaky, I've said it many times in the past, squeaky wheel gets the oil. So you have to make some noise, things taken care of until your calculation is correct. But it's not just the back pay, it's the effective date. There are a number of cases at least on a weekly basis that I see. A grant that has been granted with an award is just not correct. And it shorts the veteran a substantial amount of back pay when that effective date is not correct. And so when you are awarded a grant, a service connect increase, or a new disability, or an appeal, one of the first things you need to do is make sure that that back pay is correct. The calculation is correct. You've been paid the right amount. Make sure the effective date is correct on the award. Be sure that you have been granted the right percentage for the level of disability that your records prove. And they should not have just taken CMP exams into consideration. If your private records, I'm dealing with some cases like this right now. And thank you for this question, Mr. J. Pulo. If your private records and VA treatment records show symptomology that the CMP examiner did not mark, that will place you at a higher level, then you need to fight for that higher rating because it was of record, the evidence is of record, and it should have all been used. And the law says that the rater is the decision maker, adjudicator is to consider the whole history of a condition, not just a CMP exam. For an example, I have a veteran right now dealing with prostate cancer. Unfortunately, they only took the symptoms that the CMP examiner marked on the exam as him having to rate his Agent Orange registry exam, his private examinations, his VA treatment, cancer treatment, oncology treatment, all have voiding dysfunction at a significant level. They all have erectile dysfunction and other symptomology and residuals from that prostate cancer that should also have been rated. Things you want to check for. Don't get so excited that you've been granted an award or an increase or won an appeal that you overlook benefits that might have been missed. It just seems to be that there is always something to fight with the VA. Even when you are in a winning position. So you just want to make sure that you are being afforded all the benefits that you're due, even after you have been granted an award. Pay attention. When it comes to the VA, pay attention, advocate for yourself. If you don't know what to look for, get an advocate to review it for you. But you will do yourself well, and you would it would probably benefit you greatest to review things, character by character, letter by letter, paragraph by understand everything. If you don't, get somebody who can help you and help you understand the award letter, make sure everything was covered correctly. If something feels off, fight for what you believe, fight for what you know should be the correct thing. Good evening. The VSO said I could not file MST, secondary to PTSD, yet I was given increase for PTSD. Okay, so this is an interesting question, Ms. Walker. Technically, the VSO is right in a sense and wrong in a sense. And I have to caution you that I have not reviewed the facts of your file. He has, or she has, whoever the VSO is, him, her, pronouns matter these days. Their advice is probably more informed than my advice. Let me lay that out there. But you can generally only be rated for one mental health disorder. Very rare circumstances that people are rated for two separately. We're talking 99, just my statistics, not any VA statistics, are proven statistics. Probably 98% of the time, you're only going to be rated for one mental health condition. It is terribly difficult to get mental health conditions rated separately before the VA and the BVA, and it just generally doesn't work that way. There are rare exceptions, as with most things in life, but generally, MST is regarded as a mental health condition that is generally known as a form of PTSD. I'm not a medical professional. I'm not going to tell you that MST can also be depression or anxiety or schizophrenia or bipolar or some other mental health condition. I've seen it take alternate forms, from my perspective as an advocate. But what I am telling you is that it is not likely your best move to be claiming MST secondary to PTSD because the PTSD already encompasses the MSs, and you're not going to be rated separately for the MST. So on that front, your VA, they were giving you some correct advice. On the other front of the sleep apnea, though, I question whether that would be your best move. Generally, I see a lot of cases won and lost with claiming sleep apnea secondary to PTSD, but it certainly is a claimable condition secondary to PTSD. That's a fact. It can be claimed secondary to PTSD. What is also true is, will the facts of your file or not a nexus letter, independent medical opinion, or a nexus from an examiner, a CMP examiner, a VA examiner, say that it is in fact related to each other? Is there causation, or is it a direct result of, or is there some influencing factor that would it can be a difficult feat. I'm not going to beat around the bush or mix words. And so you, like I said, your VSO has reviewed your file. I have not. It might be that you've tried to claim sleep apnea some other way in the past and are secondary to some to another condition or mental health condition, and you need a new evidence, or they were trying to explain something to you that I'm not grasping in your question. And so I want you to be very aware when I'm advising, when I'm giving information, that I have not reviewed the facts of your file, and your VSO has. And so the best thing, what I would advise in this situation, the information that I would give you is to ask questions of your VSO. If you do not, if your VSO and your advocate tells you something you don't understand, that you don't disagree with, sometimes the best thing to do is not to just immediately run to another advocate and not to ask a bunch of questions of somebody who hasn't reviewed your file. I'm not telling you can't ask me questions. That's not what I'm saying at all. I'm saying the best thing you can do is the person that you sit face to face with, that is paying you the personal attention, is to question them. That it should not affect, it should not get on their nerves, it should not irritate them, to help you understand your case and to help you understand the fundamentals of filing claims and what it takes. And if they give you answers that don't make sense, that don't line up with the easily researched materials that you find, that might be the time that you seek other help. And so just ask some questions of your VSO, try to get understanding there, because on another front, sounds like it might be another little, but they might have reasons behind it. I get some clarity there. Good question here. Why does female sexual arousal disorder only get 0% rating unless trauma? The reason that it only gets a 0% rating unless there's trauma is because that's what's called the schedule of rating disabilities. The guide, the law, it's actually a law, a statute that dictates what every disability, whether it's a knee, whether it's a back, whether it's a foot or a heart condition, the schedule for rating disabilities dictates what every disability gets rated and at what level that disability gets rated at. It's very clear. Sometimes it's black and white. Sometimes it can get a little cloudy, but most times it's black and white. And for the condition that is female sexual arousal disorder, or what is rated analogously to, because it's not necessarily on the rating schedule, so it's rated, that is on the rated schedule, that's called being an analogous rating, because it is analogous to the loss of a creative organ or erectile dysfunction. The higher rating than 0, there has to be some trauma. There has to be penile deformity to get to 20%, I believe is the next highest level. And so that is analogously to erectile dysfunction. If there is no penile deformity, if there is no trauma, then you it's the only option left. The non-competing is the only option left for female sexual arousal disorder. And so that's why it gets rated. It only gets rated 0 in most cases. There are times that it does get rated higher if there is deformity or something that could be interpreted and analogously compared to deformity, which I think is a key element of that next higher rating. There could be other elements that I'm not naming off the top of my head, but that's the key element. Generally 0% is the only option, or the general option that people get when they claim and are granted FSAD. The good news is that FSAD is considered the loss of use of a creative organ, and so it comes with what's called special monthly compensation. Special monthly compensation is a extra benefit laid out and dictated by Congress, that in a law that is over and above any percentage that you may get. So it's not extra percentage, it's extra compensation. And in the case of female sexual arousal disorder and its comparable, male disorder, the erectile dysfunction, it usually gets rated, usually gets SMCK, what's it called, special monthly compensation K, and it's about $120, $130 or more a month that you get paid. So while you are only getting a 0% rating, you are getting extra compensation with the female sexual arousal disorder. So many times it is to your benefit to, if you have that condition, to claim it and let it get awarded so you get that special monthly compensation. Thank you for that question, Ms. Always. All right, Mr. Marvin. If you submit your claim with the nexus letter and DBQ, from your personal doctor, do you have to attend the VA CMP exam? Oh, you're trying to get me caught up here tonight. I see. This this is an interesting question and nuances. And well, I will say this. I will give you my Carmella statistics. These aren't written anywhere. They haven't been researched, studied, proven. No professor has calculated this. No statistician, no math. But off the top of Carmella's head, I'm going to give you what I see, what I think I see, I believe I see generally in my cases. 85, 95, 90% of the time, it's to your advantage to still attend the exam. It will, there's some element that was lacking in your file that the reviewer who made the choice whether to order an exam or not felt that you am. So what I'm saying is 85, 90% of the time, it is Carmella's advice to her clientele, and they can make the decision themselves because I'm the advocate, not the veteran. And they hold the ultimate decision-making power. It is not 85, 90% of the time in my research statistics, I'm telling a veteran to go to the exam. There is another 10% of cases where I feel like, the reviewer might have, or I believe, or it is my opinion, professional opinion, that it is not to the veteran's advantage to attend the exam. Those are special set of systems, where all the elements have been met. The evidence is sufficient for rating purposes. There is no, it's just, I feel like it would be development to deny, which is not lawful case law wise. I feel like the VA is just trying to develop evidence against the veteran case. It's not helpful to the veteran to attend the exam that I might advise that a veteran not attend. The law provides, in most circumstances, that if a veteran fails to attend a CMP exam, now there are exceptions. This is a very nuanced question that you're asking, and so my answer is just trying to give you the best answer I can, off the top of my head, and what's top of mind, front of mind. And so take that into consideration. There where if the facts of your file are already proven, the VA is just trying to develop evidence against you, and it would not be to your benefit to attend an exam. I would have a VSO, to have a claims agent, to have an attorney, somebody who's well-versed and competent in this work and in advocacy and in VA claims, to take a look at the situation and advise you officers. There are a number of organizations, American Legion, DAV, Veterans of Foreign Wars, your county and your state usually have veteran service officers. A lot of them do great work. And to have somebody review the situation and just give you some quick advice. They don't have to file your whole claim to advise you on a situation, but if you're not sure whether you should attend an exam or evidence against your case, seek advice instead of just not attending the exam. It could hurt you. It could get your claim denied. I got to caution you. I've got to give that disclaimer. Not attending the exam. And it could be that the person, the adjudicator, doesn't take that positively. This is a good segue here to say this. The people that examine you, the people that adjudicate your claim, that decide whether you go to an exam, that decide whether you're granted service connection or whether what percentage you're granted it at, the people that review, the judges and the attorneys that look at your case at the Board of Veterans Appeals, they are human beings. Okay, they're human beings. They are subject to error. At the regional office, I tend to believe, it's Carmella's opinion, that there's an abundance of error in a lot of cases. I think, amicus briefs and other things that the Supreme Court have lent credence to that opinion of mine, observation of mine. But they're human beings. And, the point I wanted to make is, if you do things that, have been ordered and you kind of seem rebellious, like you don't want to comply, that can be taken into consideration. It should not be consideration. There's an actual law. I used it just this week in a veterans case where I was pushing back hard because I felt like there was an error being made in the case. That talks about the attitude of rating officials. And it says, even if the claimant becomes abusive in demeanor or position, or I suppose in so many words it says disrespect, the rated officer is still supposed to have professional courtesy and not take that into consideration when adjudicating the claim. And so, but we all know people are human, is what I'm saying. And sometimes if it seems like if you're pushing back too hard, it could go against you. And so you want to take the human elements of your actions into consideration too. Like I said before, most of the time it's my advice to just attend the exam. Sometimes that's not to your benefit. I know there are lots of these unaccredited consultants and companies that are producing medical evidence and then telling the veteran not to attend an exam. To me, that's questionable practice itself, because that blanket type evidence to everybody you produce a nexus letter for is not always the most effective thing. And so, Mr. Marvin, this is the answer to this question is extremely nuanced. It's situation dependent. It depends on the facts of your file and the quality of the medical evidence that you've submitted. Is what you've submitted, the next letter and DBQ, sufficient for rating purposes? That's the central question. That's the foundation of the decision on whether you should attend the CMP exam or not, or whether the VA is just developing evidence against you, and that's against the law. That's unlawful. And so you have to be able to make all those considerations intellectually and with the human elements of the situation, and be able to come to an informed decision. Like I said in the last two questions, if you can't make those considerations yourself, I would find a competent professional advocate, whether a BSO, a claims agent, or attorney, and get somebody on your side who can reason all the factors and give you an informed opinion. I hope that was helpful. San Diego, California in the house, Texas, West Virginia. Here we go. Next question. A lot of folks on YouTube tonight. Thanks for joining me. Good evening. Would GERD and IBS be secondaries worth going for as secondaries for medication to depression? Mr. 910, sounds like you're in my area. 910, that's good to see you. Home team. Would GERD and IBS be secondaries worth going for as secondaries for medication for depression? If your medical records and a medical professional and others have dictated to you that your medication that you've used over time has caused GERD and IBS or been a contributing factor to those conditions, certainly worth pursuing. Those are conditions that I commonly see, that I commonly claim for my clients, and that commonly get service connected. Doesn't mean that it's guaranteed in your case, just means it's a valid possibility. And it's worth exploring. Professionals that treat you or asking questions of what's, because no two VA claims are the same, no two medical or situations are the same. So you have to ask the medical professionals in your life, is this what happens in my case? Hopefully a VA and your conditions will get service connected. But yes, it's certainly a valid claim. It's not frivolous. A request received a request a release for VA records. VA was unaware VA could get my records. Yes, they could. Okay, I understand what you're saying now. Sorry, it took me a minute there to catch your drift. And I just realized I didn't have my overlay up. So y'all forgive me. Received a records release request for VA records, was where VA could get my records or couldn't get my records. So VA records they have. What they asked you for was to release your private records to them or give them permission to go seek your private records on your behalf, private treatment medical. My advice to my clients usually that it's much faster, claim better, and it would probably make you happier and more satisfied If you just went and got those records off the online patient portal of your private physician, or called the doctor's office, or stopped by and picked up those records, sent them to me, and we submitted them, that could happen in probably 24 to 36 hours time frame. We could have those records to the VA, and the whole situation could be handled. The VA can move forward with your claim. Rather than filling out that form, sending it back to the VA, having to wait for the VA to receive it, having to wait for them to act on it, send out a letter to your doctor for your doctor to respond, and then the VA to get receive those records back and act on it. Do you see the difference in those processes? So that, I believe, it is my opinion that form is kind of a little misleading and a little unnecessary. In most cases, it's to your benefit to just get the records yourself, your private treatment records, and submit them to the VA, or have your advocate submit them to the VA. That would serve you better. Yes, they sent you a release. They usually send it to all claimants, or most claimants, that ask you to if they can go get if there are any private treatment records, and if they can go get them. What's true is that it's much, much faster. Your claim would likely move much faster if you just got the records yourself and sent them to the VA without returning that form. The form, I believe, it slows down the process. It'd be nice if they added. I don't mean to say it's misleading, but it would be nice if they added a section to the form that told you these things. So you can either turn the form in, or you can get the records and just submit them to us. I think the form should say that too. That would be helpful. Y'all are sweet. Just somebody here to say thank you. Thank you for joining me tonight. All righty, Sacramento, Ohio, Alexander, Virginia. I was expecting. Here's the question I was expecting tonight. Is the PACT Act automatic? This is a loaded question. What the PACT Act does a lot of things. It's a huge piece of legislation, hundreds, if not thousands of pages that I have not myself made it all the way through yet. I'm only scratching the surface. And so it was my intention at the beginning of this broadcast tonight to tell you all that at this time, I'm probably not the best source of answering on PACT Act related questions, just because I need to make it through the legislation, digest it myself, and not just be digesting other people's summaries of it in order to properly advise on it. It's a major piece of legislation. It's huge. It provides much. Interpret it and be able to advise on it, on a live basis like this off the top of my head. If my client were to ask me a question, off broadcast, I could go research type of thing. But be able to questions on camera takes a whole different skill set and a whole different knowledge of the law that mostly I grasp in other areas. But this legislation is so new that I'm still wrapping my hands around it. I'm just scratching the surface. And so if there's any other questions, I might just look over them. Don't think I'm just bypassing your question. But if it's PACT Act related, in my next broadcast, or probably November, December, I'll probably have a little bit. But to answer your question, this is a pretty simple question. Although it's a loaded question. There are many things. There's nothing about the PACT Act that's automatic that I'm aware of at this point. But there are many things many conditions, or I think another 23 conditions that the PACT Act made presumptive. What presumptive means is that if you have it and you have the condition within the time frame that the law provides for, and you were in a location that the law provides for, that there should be service connection should be presumed. That could, I guess, a synonym for that is automatic. Should happen automatically. It just in VA veterans law world, another way to interpret that means that you don't have to prove the nexus between the two. If you have element A and element C of a usual direct service connection claim, then element B should be implied. And so it just gives you a greater likelihood of being granted those conditions if you have them and you were stationed where they at. It should be granted. There are probably some cases. I mean, it's a beast of a piece of legislation. So there are probably going to be some. I don't believe anything is going to get granted under the PACT Act. From my current understanding, I probably shouldn't be advising on this at all. But until January 2023. I could very well be wrong. Don't quote me on that yet. Give me a couple months to digest it, and I'll be back with you. But is the PACT Act automatic? I think a better term is presumptive. There are things that were additional conditions that were made presumptive, additional locations that toxic exposures and burn pits became part of the law to be granted presumption under service connection, presumption of service connection, and that benefit likely millions of veterans. The VA has said that they will start accepting PACT Act claims immediately. So it's your benefit to file the claim. If the claim can be made now, to your benefit to go ahead and file it and to let the VA adjudicate it. When it can be granted, they should grant it. So if you have a PACT Act related claim, you are stationed in one of those locations that fall under the PACT Act, and you have the condition related to one of those locations, file the claim now. Do not delay, do not wait, and get it on record, hold your earliest effective date for the matter. That would be my opinion. Thank you for the question. All righty, lots of people in the building. Boulder City, Nevada, Hampton, Dothan, Alabama. Here we go. Hi, Karen from New York. I did my CMP in June, and I still have not heard anything from the VA. What I would tell you is that it's getting a little on the long side where you haven't heard anything from the VA. It could be the factors at play. You want to follow VA.gov, check in with your professional advocate representative if you have one. They try to see what they might be able to see in the electronic system if they have electronic access to BVMS, where they can see exactly what a VA employee can see about your claim. But it's getting a little on the long side. It's been 9 months now. Today, September 1st. You had a CMP in June. I'm sorry, I thought that said January. So June, July, August, September. It's been 3 months. What I would tell you is that the average amount of days right now to adjudicate a claim is between 120, 140, and you're actually not on the long side. You're maybe a little still on the early side. Things are not quite abnormal yet. So you just want to follow the status on VA.gov and check in with your advocate to see what's going on. And if anything needs to happen to speed it along, if you have a hardship, financial hardship, if you are terminally ill, if you are over the age of 85 and it's at the regional office, you want to submit a priority processing request and try to get that sped up, your claim sped up that way. But if none of those are the case, then it's just a standby type situation. I know the wait is anxiety producing, and it is not fun. Likely money due you that you need on to for things to for the better your situation and the better your life. I understand all the factors involved and the elements that are anxiety producing, but it takes these things. Adjudication of a claim takes time, and like I said, you're a little on the early side if you just had a CMP. While it should have been adjudicated by now, it's not necessarily at an abnormal point. So unless you have a hardship that would lend itself to a priority processing request, it's just a standby type situation. Check VA.gov, check in with your advocate, and if there's ways to get that claim moving, your advocate should be able to help. Good question here we got coming up next. Is it okay to file more than one claim at a time? Mr. Israel from YouTube, yes. It is okay to file more than one claim at a time. Now, there are exceptions and nuances that come with that I could probably go on about for about another 20 minutes. But generally, yes, it's okay to file more than one. Is it probably advisable to file more than one claim at a time? And I say that because if you have previously filed an intent to file before you filed, or you are just filing all the claims at once, maintains your entitlement to the. And so if you file one claim today, another claim next month, you're going to have a bunch of different effective dates instead of the earliest one you could have. After you have an intent to file on file, if you file different types of claims, a new claim, a supplemental claim, an appeal, a higher level review, if you don't file them all on the same day, then that intent to file is only going to apply to the first claim that you file after that intent to file. What you want to do is get the earliest effective date for everything for continuous pursuit involved. So generally, it's advisable, or I would inform you that it's to your benefit to file more than one claim at one time, or file everything that you have to claim that's ready to claim at the same time to maintain entitlement to the earliest effective date, and get the highest retroactive award. We got a long one here. Let me try to work through this. So I'm just going to take a couple more questions. Almost at our hour. Thank y'all for joining me tonight. Hope so how did I go about attempting to get rated for GERD secondary to paperwork dating all the way back to 2008, but I got out in 2005. In 2016, I actually took it to the VA and they diagnosed it as well. Finally, let me see. I always had heartburn, reflux, but I got out in 2005, took it to the VA. I always had heartburn, reflux, but never really went to the doctor for it while active. Just turns out, brought Tums or Zantac and went about. So it sounds like you had the conditional active duty. There's a couple ways to approach it, and I would generally advise to explore all theories of service connection that for everybody watching that you might be entitled to. Sounds like there might be a direct theory here that you might have some entitlement to, and a secondary theory, secondary to PTSD or another service connected condition that you may have. With the late statement, you know that you took that Tums or bought that Zantac on active duty, or somebody could verify that, a buddy or a spouse or something like that. It might be worth pursuing directly related to service that GERD, that it was, you had it on active duty. You've stated that here, and you still have it. It's been continuous since, and it sounds like a chronic problem. You have all three elements of direct service connection. Now, is it hard to prove when it's not documented? Yes, it becomes a challenge, and that becomes the option. But the guidance also states that the absence of the issue being documented or the condition being documented in the service mean that it was not factual. Put another way, that just because a veteran didn't go to a doctor, or a service member didn't go to the doctor on active duty when something was painful, does not mean the pain did not exist. The condition did not exist. For instance, personally, my left wrist, you see my scar here from surgery, my left wrist has been painful for the last 3 or 4 years. It is chronic, it is every day, and it is constant. It's not severe, probably mild to moderate at some days, when it's flared up, but most of the time it's just, a mild aching type constant pain is there. I'm aware of, and when I'm, relaxed, I'm aware of it. And so, but I have not been to the doctor for it in about 3 years, to be honest with you, because I got tired of them not fixing the problem. And so, so that does not mean that my wrist pain has not been a active and real problem for me for the last 3 years, because it has. I just taken Tylenol and whatever I could take. And the same thing works with your service treatment records. Just because you had a conditional service, which is exactly what you're telling me, had the GERD on service, and service treated. It's not documented because you didn't go to actually go to the doctor for it. So, or if you did, they just, advised you and didn't document it. So there's, with a strong late evidence, that might be a case that could be one at the RO, probably better brought at the BVA, but it's direct service connection is an option there. Secondary to PTSD is also an option. It's a claim I see often. I can't speak to your specific case or the facts of your file, but it is a possibility. If the medication you've taken for PTSD is probably the usual way that I see it connected, has influenced or aggravated or worsened that GERD, that is what you want to make clear in your claim. If you're claiming that the GERD is caused by the stress and it flares up with the stress of PTSD and the elements of your mental health condition, that's what you want to make clear in your claim. Yeah, it's you have a direct and a secondary type situation, both that you can pursue there. So take full advantage of all theories that are available to you. Okay, so I've had 2 CMP exams, 2 and 5 years at 100% rating. Went online to see when I would be called back again. I'm listed as PMT now, but was never informed of that. Is this a mistake or sometimes not informed? Sometimes you can be not informed. If you're listed as permanent and total, you're more than likely permanent and total. There has been a recent effort by the central office, the VA central office that's over, the rated offices. Well, they're not really over rated offices, but they put out the policy and the guidance and stuff like that dictates how claims are rated and how regional office procedure works. That has moved to eliminate reevaluations and unnecessary reevaluations of reevaluation exams, and they have just been seeing whether permanent and total should have been granted, and they should have. When a VA takes an action like that, they have a duty to notify, to write you a letter or give you some type of notification that action has occurred, but that could have been skipped or missed. So concerted effort to eliminate unnecessary reevaluations going on at the VA right now. And yours could have been one of those cases. So it could have changed to PMT and you could not have been informed. That's a real possibility, but they should have written you a letter. Probably 75% of the time, that's a Carmella statistic. No, not hard and fast. Don't quote me. Probably 75% of the time, you should have got a letter about it. So go back through your mail or call the 800 number and see if they can resend. Ask the call center person if there's a letter on file about the change to permanent and total, and if they can maybe you missed it. But if they say there's not, then they just changed it and they didn't tell you. So that might be what I advise. All right, this is a good question. What does a CMP favorable finding mean with the denial? So under the Appeals Modernization Act 2017, implemented in 2019, February 19, 2019, VA started their rating decisions, writing out what I call favorable findings. It's a new element just started in 2019 under the AMA Appeals Modernization Act. And what is simply the law Appeals Modernization Act simply dictated that even in the case of a denial, the adjudicator is supposed to tell you the parts of your claim that were positive, the parts of your claim that were favorable, that flowed in your direction, that lended credence to your claim and credibility, those elements for you. And so that's what favorable findings are. They're findings that are favorable to you, simply what it states. But there was some element that was lacking and that they could not grant service connection. Some element of service connection was lacking. Service connection could not be granted, but there were some elements that were met, and those elements are listed in the favorable findings. That's all the favorable finding is. The VA is bound in future decisions by those favorable findings unless it's overturned by clear and unmistakable error, which is a very high legal standard. But generally, the VA is bound by those things, and it should serve you well in future claims to use those favorable findings as a foundation, a move to satisfy the elements that are lacking or missing. So yeah, favorable findings are a good thing. Even if, it's just like a little rainbow at the end of a rainy day. It doesn't mean that the pot of gold is there. Just means you saw a little bit of sky and a denial. Little silver lining to a cloudy day, right? Gonna skip that question. I'll get months when I'm more knowledgeable in the situation. Applied for TDIU and ended up 100% PMT. TDIU total disability, individual unemployability is moot, they said. Denial lymphoma in February 2000, worth it to appeal for new PACT Act presumptive. I didn't know this was a PACT Act question too. If lymphoma is, I'm not sure lymphoma is presumptive under the PACT Act. Could very well be wrong. If it is certainly worth. And it's, I believe that's cancer, skin cancer. If I'm right, I could be wrong. That's off the top of my head. But if it is presumptive under the PACT Act, then even at 100% PMT, the lymphoma might be worth appealing. First of all, it might be worth appealing if there's additional back pay that could be gotten. Okay, if there's an earlier effective date that lymphoma will grant you to be able to grant the 100% earlier, it's worth appealing. And then second of all, if that lymphoma could help you get special monthly compensation, if it's active and it would be rated 100% on its own or at some time in the past, and you have another set of percentages that add up to 60% or 60% alone, just one that's 60% alone, then you will be eligible for a special monthly housebound rate. So there's additional compensation available to you for that cancer being active for the time that it is active or under watchful waiting and not in remission. And so there's a lot of reasons to pursue it if indeed it is presumptive under the PACT Act. I don't know for sure off the top of my head. So I would get with another advocate or your advocate or somebody who could answer this question better than me for the time being. Like I said, I'll probably be well versed in it in a couple months. Give me till January. So it's a beast of a piece of legislation. We're all working through it together. And so I need to read the text myself and feel comfortable with it before I give some solid advice. But take that into consideration. But generally, if the cancer with lingual 100% rating and you have things that total up to 60 otherwise, you might be eligible for special monthly compensation over and above the 100% rate at the housebound rate. And so it is to your advantage to pursue that lymphoma on appeal. And with that, folks, I'm going to wrap it up for this evening. Thank you all for joining me. It's a pleasure to come on every month to answer these questions. I'm going to try to get a special guest with us next month to answer questions with me. I will try to spice it up a little bit every other month. And so I want to thank Leah Buckles, a Prestige Veteran Medical Consultant, for filling in for me last month. I was in Guam with some training, some folks that are going to become veteran service officers there or become a VA accredited to do claims. I had a great time in Guam. The wonderful people in Guam, very hospitable, beautiful island. And Leah Buckles, a medical professional, filled in for me on the show as a host while I was away. So thank you, Leah. Special shout out to you. Prestige Worldwide, Prestige Veteran Medical Consultant is an excellent outfit there. So take advantage of their offerings. If you need them, there are other companies that offer great services too. Not picking one of the over or anything like that. So, but just giving a shout out to her for filling out in for me at the last minute while I was in the air, headed to Guam, 20-hour flight. She, I reached out to her and she was able to fill in, and I'm thankful for her presence and her doing that. So shout out to Leah, thank you. And generally, I wish y'all well in your claims. If you're eligible for something, take advantage. Do your research. Reach out to an advocate if you need it, and take available of every benefit available to you for your military service. So y'all are awesome. I love working with each of you, and thank you for joining me tonight and listening to me. This monologue going on for an hour. Just talking. It's an honor that you joined me. So I will be praying for you and your claim. And have a good night.